Hi guys. So today we are going to see about the fundamental rights in the Indian Constitution. So basically fundamental rights is the basic rights one Indian person should have. So which is called as fundamental rights. So our fundamental right is called as the Magna Carta of India. So basically Magna Carta is the royal charter for rights which is subject to law, something like that. So for India the fundamental rights is considered as the Magna Carta, and fundamental rights is the cornerstone of the constitution. So basically cornerstone is, for example, if you take a building, means the corner is important to hold the top of the building. Likewise, the fundamental rights is the important cornerstone for the constitution. And the fundamental rights with the directive principles of state policy, which is called as conscience of the constitution, which is basically the soul of the constitution. So the fundamental right provides the political democracy, which means people rules. So it provides the good way for the people's democracy, which is called as political democracy. And the fundamental rights are enshrined in part 3. So enshrined basically means so added and preserved. Likewise, so fundamental right is considered a kind of preserving thing in our constitution, so which is in part 3 of the Indian constitution from the article 12 to article 35. So let's start with the article. So article 12 states about the state's definition. So here the states are mentioned in the different form. For example, in a particular article, if a person, there is a thing between person and the local state government, that in that place state means original state is denoted. For example, Tamil Nadu, Kerala and some other states, because in our Indian constitution no words of India, some things are not made out. So they, instead of this, they use only a single word called state, but the state word will have a different meaning based on the where it was used. So likewise, if there is a thing between a person and the local government, here the state refers to the local government, and there is a thing between something to the union government, the state denotes the union government. So the meaning of the states differs vary from the where it was used. So the next one is article 313, so which is the laws inconsistent with fundamental rights become void. For example, if any law doesn't obey the fundamental rights, it becomes the null or void, which means it is an empty, it is not considered as a law. So which is article 13. So right to equality. For fundamental rights, seven basic things are there. The first one is right to equality. So let's see about right to equality. The first one is article 14. So basically article 14 means equality before law, which is called as rule of law, and equal protection of laws. So what does it means everyone before law is equal. There is no difference between one person to another person. So everyone in front of law, they are equal. So which is called as the equality before law. In some other cases, this doesn't obey. For example, if any president or governor cannot be arrested directly, likewise based on the newspaper, if any allegations are made or accusation is made on some of persons of the president or the persons in the higher official, they can't be arrested directly. Likewise, there is no thing on the MP's vote. For example, MPs are voted in the parliament and they have the rights to talk all they want to. So for these kind of situations, equality will not apply. So these are the some of the um, exceptions that were made in the equality. So which is called as the immunity power for those persons who are in the higher positions. Some reasonable restrictions are made for them. Next one is article 15. So article 15 is the prohibition of discrimination on grounds of religion, race, caste, sex or the place of the birth. For example, a particular person is not differentiated because of their religion or their race or their caste or their sex or their place of birth. So on these things, a person should not be differentiated from one person to another. So there are some other things inside this article for 15 class of 1, which is talks about the ground. What are the, on which basis the discrimination not done. So on the basis of religion, race, caste, sex or place of birth, the discrimination should not be done, which was talked in the article 15 class 1. In article 15 class 2, So some peoples are not allowed in public place because of the discrimination. So that should not be done. So it should be avoided, which was talked in the Article 15 Class 2. Article 15 Class 3 talks about the reservation for the women and children. Article 14 talks about the reservation for the SC/STs in government educational institutions. So this was added in the first Constitutional Amendment Act of 1951. So Article 15 Class 5 deals with the reservation for SC, ST and OBC in private and government organization. So which was added in the 93rd Constitutional Amendment Act of 2005. So for this, a particular act was made which is called as Central Educational Institution Reservation in Admission Act 2006. So for this reservation, a particular act was made in 2006. So next one is Article 16, which is called as Equality of Opportunity in matters of the public employment. So in public employment, everyone should have the equal opportunities, except there are some of the exceptions here we are also. So employment should be based on the equality, which is talked in 16 Class 1. In 16 Class 2, on the grounds of the race, religion, caste, sex or the place of the birth or residence, they should not differentiate one person to another person. But for this, Parliament can only make law on this matter only. Then the 16 Class 4 talks about the backward classes peoples can be provided public employment. So in 16 Class 4 Class A, SC/ST people reserve, they can get the reservation on the particular matter. So this should be on the limited matter. So you can't give directly to any reservation to particularly these people amount high reservation and these people got high reservation. So some these things should not be allowed at. So for this, some of the reservations are happening in India. There are so many cases based on the reservation. So the first one is in 1951, there is a case called State of Madras versus Champakam Dorairajan case. So which this case leads to the first Constitutional Amendment Act of 1951, which was added as the 15 Class of 4. Basically, these reservation cases should not be conflicted with the other fundamental rights. So this is the important thing while we are creating some of the reservation for the particular people. So the next one is Indra Swane's case, which was in 1992. So which tells in among BCs there should be two categories. The one is called creamy layer, the another one is called non-creamy layer. So as of now, if a person's monthly income, or if a person came from a family, that family's the family's annual income is more than 8 lakhs, so they should come under the backward classes creamy layer. So if a person's family's annual income is come less than the 8 lakh per annum, so they should come under the non-creamy layer. So for the person who are in the non-creamy layer will get the reservation because they are economically weaker while compared to the creamy layer person. So for these kind of restrictions have to be made for the persons who got the reservation instead of giving reservation to all the peoples. So this should have to be implemented. The next one is, so for these cases, this should have it have been added in the 77th Constitutional Amendment Act of 1955. The next one is Nagaraj case of 2006, so which added the reservations for the SC and ST people based on the social and the economical status. So for these kind of giving status, there should be a quantifiable data. So without any data, we can't directly say give this much reservation to this kind of people. So we can't say directly like this. So we should have the valid quantifiable data to justify our request. So the next one is Jarnail Singh versus Lakshmi Narayan Gupta case in 2018. So for this, they said the quantifiable data is not required for the reservation. So these are some of the important cases. Then in these cases also, the 10% for reservation for the economically weaker section has been provided. So these are some of the important reservation cases which has happened in India. So the next one is Article 17. The Article 17 is for the abolition of untouchability, prohibition and its practice. So basically untouchability means, so it's a discrimination based on the caste. So this should have to be abolished, and as well as its practice have to be prohibited. So for this, an act was passed which was called as Untouchability or Offences Act in Act of 1955. So in 1976 it is renamed as Protection of Civil Rights Act of 1955. So these are some of the act which leads to the importance of the abolishing the untouchability, and there is not explanation for the untouchability in the constitution. So our constitution has more than many words written, and it has the longest written constitution in the world. But in our constitution, there is no particular explanation or meaning for the word untouchability. So Article 18 is talk about the abolition of titles except military and the academic. So it have a person has the rights to have a prefix or suffix by adding a military titles like lieutenant colonel, lieutenant general, likewise, and the academic academic titles like doctorates. So these have they are, for these titles they have the rights to added. But if there is some other awards like Bharat Ratna and Padma awards, they should not be added in their name. They should be added before their name or after their name, like prefix, like so Padma Shri and the name and the Padma Shri are some of the kind of things or titles should have to be avoided. So this is should not be added. So this is should not be encouraged. So according to Article 18, 18 class, so it states that the Indian should not get any foreign titles. So the Indian should not have the rights to get any foreign titles from the foreign countries. And the Article 13 class of 3 talks about the if a person is not an Indian state but he or she working in an union government, means they should have to be get the approval from the president to acquiring the any foreign title. So if a person is an Indian citizen, he or she should not accept the any of the titles from the foreign state. But if a person is from the foreign state but working under the union government, he or she should have the permission of the president to acquire those titles which was came from the foreign state. So the next one is Article 18 class 4, so which talks about if an Indian citizen also if working in an union government, he or she should get the approval from the president so to receive any gifts or present which was came from the foreign state. So this is all about the right to equality and the introduction of the fundamental rights. So thank you.